Speaker. Thank you, Mr. Speaker. I rise to take a call on the Hurunui Kaikōura Earthquakes Recovery Bill and offer the Green support for this to Select Committee. The bill does two significant things. Firstly, it extends the resource management timeframe for people in quake-affected areas to give notice to the consent authority that emergency works have been undertaken. It extends that from 7 days to 40 days, and also extends the timeframe in which any required resource consent must be applied for from 20 days to 120 working days. And the second thing, which is the subject of most of the debate this afternoon, is that it enables the government to introduce orders in council to amend or override primary legislation. Now, the purpose of this bill is clearly to assist affected areas with economic recovery, planning processes, rebuilding, recovery of land and infrastructure, and with increasing resilience. And this is obviously a very important purpose. And the Green Party is right behind the quake-affected communities. We are absolutely committed to do what we can to ensure that they get the support that they need, and that this support is actually what they need, and not just what the executive thinks they might need. So we're also understandably cautious about the danger of important, precious services or environments being irreparably damaged due to rushed processes or smart ideas from the beehive. Passing legislation that gives the executive the power to override legislation that's been passed by the will of Parliament is no small thing. It is something to be avoided wherever possible. Legislation, however imperfect it may seem to me at times, represents the will of the people, and provisions in primary legislation are usually there for a reason. We must, however, acknowledge that in times of disaster, the context changes significantly, and processes that may normally be beneficial may no longer make sense, or in fact may create unnecessary barriers to recovery. We also acknowledge that response and recovery are complex, and it may not be possible right now to anticipate accurately the exact needs of a community, and that passing specific bills for each specific need, when it may be urgent, may not actually help the communities at the time. So passing legislation like this gives considerable trust to the executive to accurately assess whether an order in council is necessary, how long it should be necessary for, and what changes will provide the best result for affected communities. We're happy to support this discussion going to the Select Committee and share the concerns, though, that have been raised by the Labour members, that it does feel that reporting back on Tuesday does feel too quick and unnecessarily shortened, and that was a learning from Christchurch, is that at this end we should be taking the time, not excessive time, but just enough time for people's views to be able to be inputted into this process, because there are huge things at stake with this legislation. But we are happy for it to go to Select Committee, noting that there have been significant changes and some safeguards put in place, and we want that balance to be checked in the Select Committee process. So things that have been added to this that weren't there in terms of Christchurch are that in legislation, there's a requirement that the order must be necessary or desirable for the proposed purpose, and the extent of the order must not be broader than is required, and that will be able to be tested in law. There is a list of acts that an order can relate to, and there are 40 acts on that list, though there is still a provision here for the government to be able to introduce an order in council to another act that is not on this list. But we've been told that the ability to do this will be limited to times where this House is adjourned, where it's not possible for the House to come together and check that particular plan, and that when the House comes back, that new act would and that order would need to be positively confirmed by Parliament, and so that Parliament would have the opportunity to say, actually no, we don't think that's valid, and that the Order in Council would lapse at that point. So that is a significant check. Also, that with this legislation there's an establishment of a review panel which has designated places for iwi and local government reps and legal expertise. And I share also the view, I think, of David Parker, that it may make sense for that legal expertise to be a judge. And that panel will provide advice to the relevant minister on the proposed order in council, and that their recommendations on the draft order must be publicly available on an internet website. The Greens will be proposing that there be environmental expertise on that panel when an order in council is relevant to the protections of the environment. Also, that there is provision here for, or there was initially provision for engagement with substantially affected persons in the legislation. I understand that has been taken out in the draft that we have with us at the moment, and with the understanding that that will happen naturally through the processes, and we will certainly be having discussion in the select committee stage to check people's comfort with that point. In the initial draft that we saw, it was about the people that the minister considered substantially affected, which we had an issue with as it was, so we will be interrogating that point in the committee stage. It will also require that the minister publish the reasons for recommending the order of council, so that will be open to public scrutiny, and that the Regulations Review Committee of Parliament will have also a chance to look at the draft, and if the House is in adjournment, then the party leaders will get a copy of that draft. So it will be open to scrutiny, at least, if not a vote in the House. And that orders it is important to note that orders once made are not legally challengeable, except that Regs Review do have the ability in certain circumstances to overturn, is my understanding. And there is a time frame on these orders. Apparently there's an expected limit for good practice of orders in council to be up to between 3 and 5 years. This is until April 2018, which is significantly shorter than that time. And there's a note in the legislation as well that they last until April 2018 unless sooner revoked. And I do want to particularly point that out to interested parties, as I believe that implies that there's potential value in lobbying the minister if, in the event, any interested party thinks that an order that has been put in place has served its use, that there is possible to have the orders no longer be taken off the books, I guess, before that completion date, if they're no longer necessary or desirable for the proposed purpose. But there is no avoiding the fact that this bill does give significant powers to central government and removes proper consultation provisions and rights of appeal. But that has to be balanced, and we really do understand that that has to be balanced with the needs for government to support communities to be able to recover. We will be looking through the select committee process, though, to make sure that that process just really does understand the need to protect our environment and get that expertise in the process, because there are some changes that you can never undo. And it is, in times of emergency, very easy to rush into making decisions that may cause irreparable harm to our environment, and we want to make sure that everything possible is done to prevent that possibility. So we are supporting and would like to acknowledge the Minister for the process up to this point.